Good afternoon, everybody. My name is Peter Zimroth. I am the director of the Center on Civil Justice here at the NYU Law School. And I want to thank you for coming. We appreciate very much your being here. So this afternoon's conference is a celebration of the launch of the Dispute Financing Library. That library is available for free at www.disputefinancing.library, all in one word, disputefinancing.library.org. And what it is it's a neutral repository of documents and information on third-party litigation funding. We hope you all go to the site and use it and find it useful. Now about today's program. At 1 p.m., or soon, actually, maybe in a few minutes before 1, if I can get through these initial comments quickly, which I intend to do, we have a keynote speaker by Richard Painter, who is sitting on my left. Professor Painter is a professor at the University of Minnesota Law School, former chief White House ethics lawyer under President George W. Bush, and I'm sure many of you have seen him lately on television talking about the Emoluments Clause and other ethics issues that have been raised so starkly recently. After that, Professor Painter will talk for 15 or 20 minutes, and then we'll have some time for questions and answers. Then we'll have two panels. The first is titled Balancing the Needs of the Market and the Public, and that panel is going to be moderated by Julia Gewalb. Where is Julia? She's right there. She is the Director of Underwriting at Validity Finance and a member of the advisory board of the Dispute Financing Library. And the second is Conflicts, Ethical Concerns, and Risk Assessment in Dispute Financing. And that is going to be moderated by Tony Seaback, who's right here, also a member of the library's Board of Advisors. He's a professor of law at the Cardozo Law School. And this year, I'm happy to say he's a fellow here at NYU at the Center on Civil Justice. Now, we have a very distinguished group of panelists, but I'm not going to say anything about them. I'm going to leave that to the panel chairs. So, in addition to Julia and Tony, who are on our board, I'd like to thank the other members of the library's advisory board, some of whom are here today. And I want to say, without these group of advisors, neither the library nor this conference would have been possible. Some of them will be on one or more of one panel. Selwyn Sinell, Eric Schuler, Mark Jacobs, Chad Schmerler, Victoria Sahani, and Bernardo Cremades. Actually, almost all of them are here, except I don't think Bernardo is here. We'd like to thank also the sponsors of this conference, Validity Finance, Arrowhead Capital, and Woodsford Litigation Funding. And finally, I want to say a special word of thanks to David Siffert, the Director of Research and Projects, who's sitting here, and Shirley Dang, who is outside, who greeted some of you, our administrative assistant, who did really a prodigious amount of work to both of them to make this conference possible. One an announcement for those of you who would like CLE credit, you really need to remember to sign in and sign out. So we hope you enjoy your lunch. You've enjoyed your lunch. And Professor Painter?
Thank you so much. I'm thrilled to be here at NYU Law School. is a wonderful university here, and here at the law school and the business school. I'm very impressed with the commitment to not just academic excellence, but ethics. Ethics in business is critically important. That's what I spent a lot of my time writing on and speaking on before I ventured into the field of government ethics. And the ethics of lawyers is another topic of critical importance, and I'm thrilled to be at a law school that has such a strong commitment to ethics in our profession. I'm also thrilled to speak on something other than Donald Trump. I am a lawyer, still a member of the bar of the state of New York, even though I live in Minnesota. And yes, I am on a case that is pending in the United States Court of Appeals in the Second Circuit. Actually, we won in the Second Circuit and overturned the order from Judge Daniels dismissing the complaint in Crew et al. Versus Donald J. Trump. That's the Emoluments Clause case. But we are not looking for litigation funding for Emoluments Clause cases, particularly given the fact that really all we want is an injunction, not money damages. We want an injunction that the president comply with the United States Constitution. And that seems to be a little bit hard to get these days. And of course, the big issue is who has standing to sue the president, to require the president to comply with the Constitution and so forth. But enough on emoluments. I'm happy to answer questions, of course, on just about anything out there. But I want to talk about litigation finance and the importance of what we're doing in litigation finance. And I myself am not actively involved in the area right now, but I wrote an article back in the late 1990s about the need for more litigation finance opportunities on the plaintiff's side to address, among other things, overpricing on the sometimes of plaintiffs' lawyer services, but more importantly, the imbalance between plaintiffs and defendants. The fact of the matter is that corporate defendants have access to capital markets on a grand scale. Public companies, they can raise capital in public markets, raise capital privately. So when you sue on behalf of individual plaintiffs, a group of plaintiffs, or a class, you are up against massive litigation financing through American and global capital markets. That's what you're up against. And on the plaintiff's side, we have traditionally relied upon the lawyers and their law firms themselves to finance the cost of litigation, along with those plaintiffs who personally can advance the funds, which are very few and far between. And we depended on lawyers themselves, out of their own pockets, or at the expense of the partnership, of the law firm partnership, to advance the cost of litigation. And as the cost of litigation mounts, with discovery, appeals, and the rest of it, we see that this imbalance becomes even more worrisome. As companies, defendant companies, get bigger and have more and more access to funds, where are going to be the funds on the plaintiff's side? Where? And litigation finance is an area in our markets that could help solve this problem, and indeed is today in many ways that it wasn't 20 years ago when I wrote that article. There are important ethics issues for lawyers and also securities law issues when you raise capital for financing litigation. And I want to talk about a number of those and then open this up for questions and discussion, because I'd really very much like to hear from you about what's going on in the litigation finance area these days. For lawyers, one of the biggest issues we have to concern ourselves with is conflicts of interest. When litigation finance firms are brought in to the relationship, as they should be. The lawyers, plaintiffs' lawyers, will have relationships with some litigation finance firms and not others. And there is an inherent potential conflict of interest if these relationships are not fully disclosed to the clients involved in the litigation. The ethics rule, of course, Rule 1.7, A2, different numberings, different jurisdictions, that would say that there is a concurrent conflict, if anything, could materially limit the representation of the client. And so when you are bringing in a litigation finance firm, it is important that the client understand the lawyer's relationship with that firm and the opportunity that the client would have to pursue other options. And those are discussions that are very important to have with a client and to document in writing so this doesn't arise later. The question of, did we get a good deal, or was I just steered to a certain litigation finance firm? Was our group of plaintiffs steered to a certain litigation finance firm because of a pre-existing relationship with a lawyer? But this is one of the many problems that can be addressed through full disclosure and documenting that disclosure so that you don't have misunderstandings later. And zealously representing your client, making sure the client is getting a good deal on litigation finance. So that's the first set of issues, the disclosures between the lawyer and the client. Another problem that arises has to do with confidentiality. The obligation of the lawyer to protect the confidences of the client under Rule 1.6. And there are going to be weaknesses of every case, including the cases that should be financed, because investors take risks. And even though there are weaknesses in a case, there may be a great many more strengths. So then the question arises as to what should be disclosed to the investors. What should be disclosed to the investors? And what can be disclosed to the investors without harming the case? If you tell the investors too much, the information could very easily leak to the other side, even if it's in a private placement, which most litigation financing is going to be through private placements. I will talk about the securities laws in a moment. But disclosure to the investors of the weaknesses of the case, information that the other side might want, that the defendant might want, could be very risky. It could leak. And second, we get into the question, we're going to have to litigate the question of whether that would be subject to the attorney-client privilege. If you disclose information, or even the work product privilege, to your litigation financiers, you're going to want to be in a jurisdiction where the courts are going to uphold the privilege, or if there is no privilege, you can't disclose it or someone's going to hit them with a subpoena. You got to think that through. When you disclose information, the lawyer discloses information about a case to anyone. They disclose it to an expert. The privilege does cover disclosure to experts. I've done a lot of expert witnessing. I'm well aware of that. Until, of course, they declare you an expert, put you on the stand, and then bye-bye privilege. But at least initially, it covers the consultation with the experts. But the consultation with the litigation financiers, a lot of that may not be privileged. You have to be very careful of that from the plaintiff's side. And of course, the litigation financier, whoever's providing the funding, wants to be focused on that as well, unless they just want to be hit up with a lot of subpoenas and then have their investment dry up. So the fundamental tension here is between, on the one hand, the duty to protect confidences under 1.6 and also attorney-client privilege and protecting the privilege, the duty of the plaintiff's lawyer on the one hand, and second, the financier's request for information. And what I'd like to discuss with you and have questions about is how much information should a financier need to decide whether to fund a case? And how do you obtain that information without jeopardizing the privilege that belongs to the attorney and the client? And then we should talk about the securities laws when you raise capital. Now, there's been talk of publicly financing lawsuits. Well, you could take a single lawsuit and publicly finance it with a registration statement filed under Section 5 of the 1933 Act with all the disclosure required therein, and subject yourself to the liability under Section 11 of the 1933 Securities Act if there's anything wrong with that disclosure. Generally not a good idea. We could talk about that. Now, a public company that has a range of different investments might very well choose to invest in litigation finance, and that's different, because there would be considerably less disclosure in a registration statement for that public company or in the annual 10-K with respect to any one particular lawsuit they're investing in. But that's an issue we have to address from the securities law side. If you have public raising capital from the public, either fund a single lawsuit, which would be particularly risky, or a group of lawsuits. If you choose the private placement route, which is the way the vast majority of these, I believe, are going to be funded and are being currently funded, the private placement route, you're bringing investors with a private placement memorandum. There's a Regulation D, private placement under the federal securities laws. That's a safe harbor, or just a straight private placement under Section 4A2 of the 1933 Act. And there you absolutely have to tell the truth. You cannot tell half-truths. But there's no specific disclosure package that's mandated by the Securities Exchange Commission. And so just as hedge funds and private equity funds say, well, you're invited to participate in this fund, and we'll tell you this, but we're not telling you that. Just as long as when they tell you something, they're telling you the truth, and they don't fail to disclose anything else that needs to be disclosed for what they did say, not to be materially misleading, that works. And then that's up to the investor to decide how much information the investor needs in order to make an investment. And of course, if you have a fund that's funding a large number of a diverse portfolio of litigation, the investors are going to be less worried, not completely not worried, but less worried about the risks on any one particular case than if it's a portfolio that does not appear to be particularly diverse. But once again, you have the tension between what do you disclose to the investors and protecting the privileged information and your litigation strategy, which you may very well not want to divulge to anybody for fear of helping the other side. And this is the tension that has to be worked out in any funding relationship. And then last, we have the question of whether lawyers should share their legal fees with non-lawyers. The United States is, well, we aren't alone, but I will just say we're unique in saying that lawyers are prohibited from sharing their fees with non-lawyers, having partners in their firms who are non-lawyers, although I will point out that there's an exception to that rule in the District of Columbia, of course, because guess who wants to be partners of law firms in the District of Columbia? Lobbyists. And one need not have a law degree or any advanced degree to be a lobbyist. All one needs is a job as a chief of staff of some member of Congress for a couple of years or whatever, and then you want to go cash in on it. And so, of course, these lobbyists in D.C. generate so much more money than a lot of D.C. lawyers that all the law firms want to bring them in. So like D.C. relaxed their rule on inviting non-lawyers into the club just to keep the wheels of justice moving in Washington, say. But we are unique here. A lot of countries allow accountants and other professionals to be partners of lawyers and allow outside investors to invest in law firms much more directly than we do You know, we came close to changing those rules in the late 1990s. The accounting firms who were mounting what appeared to be convincing argument that this was anti-competitive and that they ought to be able to get into the litigation and or the legal services business. They already had a lot of people practicing tax law who were calling themselves consultants working for the accounting firm. So it was a don't ask, don't tell type of thing with the practice of law inside these accounting firms. They'd pretend they weren't lawyers. And, you know, at a certain point, late 90s, people were talking about, well, look, why just do what Europe does in a lot of places and allow lawyers to have partnerships with non-lawyers, maybe even be able to raise capital from other investors. Well, then Enron and WorldCom hit, and Arthur Andersen had a leg on their face, and the ABA came back out, told you so, keep the accountants out of our law firms. And that movement has lost steam, although it may come back, and we'll continue to debate that issue. But unless and until the rules are changed in the jurisdiction, this is a jurisdiction by jurisdiction issue. Of course, you have to look at the jurisdiction's version of the rule and the independence of the lawyer. But this can be an impediment. So it can't be the lawyer who is sharing the fees. It's got to be the client. And you're working the deal through the client. And then the lawyer is recommending the deal to the client. And then that circles back to the concerns I had earlier about potential conflicts of interest. But it is this is an area where the law may change, the ethics rules for lawyers. I'm happy to discuss that. But unless and until they do, and the lawyer has that opportunity to, in effect, fund the entire thing through the law firm, but have the law firm raising capital from outside investors, as law firms can do in some countries in the world, without violating the ethics rules. A lot of this has to be done for the client, and then you get into the conflicts of interest issues and so forth. I would very much like to have a conversation about any of these issues I've raised or any others having to do with litigation finance. I'm happy to go on in different directions on this, but I'd like to stop, and I see my students at the University of Iowa is really the expert on this, so she might have some things to ask or to point out about recent developments. She's got a wonderful website, blog post, and everything on this.
I have a Q&A mic, so if anyone wants to ask a question.
So, Richard, you're in the unique position of being both an expert in the area of legal finance, but also in securities law. So I want to ask you a question that maybe there's a very short answer to it, but the question is the following. Over the last decade, critics of the emerging market, especially the Chamber of Commerce, have published various statements where they say that among their reasons for being concerned about any change in the prohibitions against legal finance or champerty, like their third or fourth reason down the list is something that they refer to as the risk of securitization of this market. And I've never really understood what that meant. Maybe you could unpack it for this audience. I don't think they mean what you were talking about. I don't think they mean private placement. I think they mean securitization in terms of companies that are publicly traded selling off instruments similar to like when to the mortgage secured markets and mortgages. And what is can you explain what that concern is and whether or not it's a genuine concern, or is it just, as you said earlier with regard to Arthur Andersen, just a reference to a bad thing that happened in the past that should scare us off from something that we might want to do in the future?
Well, I would start with the question of how many plaintiffs' lawyers have been sued or their plaintiff clients under the federal securities laws, either Section 11 of the 33 Act or Section 10B for securities fraud. How many members of the United States Chamber of Commerce have been sued for securities fraud? And they're telling us to be worried about securities fraud. Okay. So let's just start with that. And when they say securitization, they're trying to get everybody worried that this is somehow going to be like more mortgage-backed securities that their own clients put together, or many members of the Chamber of Commerce are very much involved in that. And that somehow this is going to be this extraordinarily risky investment. Suffice it to say, though, that the vast majority of the mortgage-backed securities were actually sold to institutions in private placements. And so a lot of the securitization that's going on is through private placements, whether it's credit card receivables or mortgages or any other cash flow sold to institutional investors. And once again, the defendant's side of a lawsuit is funded through the securities markets, commercial paper that the corporate defendants can sell to fund their ongoing costs, including their lawyers. So they have access to the capital markets, and yet there's somehow going to be all this fraud when plaintiffs' lawyers and their clients have access to capital markets. So I don't see any there, and the argument, there's always a risk of securities fraud in any investment if there's a material misrepresentation or failure to disclose, and that's that which needs to be disclosed, for which you already said not to be materially misleading, that's Rule 10b-5, and yes, it exists in this market.
Well, if I was, just to take the argument one step further, I think if I could try and channel the chamber for a moment, their argument would be, the analogy would be with the mortgage-backed securities, not just fraud, but also a accelerating appetite for risk in order to maintain certain returns. Just like in the mortgage markets, there was a investment in a weaker and weaker housing market, there'll be a drive to be investing in weaker and weaker litigation.
Well, that's possible, just as it is with the credit markets, the mortgage markets, and so forth. But institutional investors have certain parameters in place. And why are they raising this issue now only with respect to litigation finance? We've never raised it for other areas of the economy. We have other controls in place with respect to the risks that should be taken by institutional investors, and those are critically important. And I've done a lot of work on Dodd-Frank, and a book came out on the ethics of bankers in 2015 called Better Banks, Better Banks. I've been through all that. There's way too much risk, too many risky investments. But what we're saying is, oh, gee, we're not going to allow this because this could be too risky? Thinks they do protest too much.
To Tony's point, there's also an underlying assumption there that you could, sorry.
Identify themselves.
Yes. This is Ross Wallen. I'm from Curium Capital, but I did a ton of RMBS litigation, so I have some perspective on the comparison between the two. The idea that you could easily package litigation risk in the way that you packaged mortgages and turn it into a AAA security at the top tranche and get that through the rating agencies and so forth, I think is highly unlikely. I don't think there's ever going to be the volume in this market that there was in the housing market to support widespread securitization. So I think for a lot of reasons, you know, the idea of escalating risk because of securitization is just, it's never even a realistic concern, but for a lot of structural reasons and a lot of fundamental differences between litigation risk and mortgage risk.
Selvin Seidel from Fullbrook. Richard, first, a question on the conflicts issue that you've raised, and second, a political question. But the first question has to do with the fact that conflicts is a terrible and untouchable problem in this industry. Everybody says that, you know, you have to align interests. Well, that's impossible, I think, to align interests. There's always conflicts between the plaintiff and the funder and the lawyer. The only thing I can think of that would deal with that is disclosure. If you disclose a situation, then the conflicts can be waived. Is there anything else you see that might deal with or address what I think of as one of the most serious problems in the industry. The political question is simply something that you and I have talked about before, and that is, can you indict a president when the Department of Justice, who has the rules on this, have turned coat and become like the president?
Yeah. All right, let's start with the conflicts. When I think about indicting the president, you all know what I'd like to do. Well, conflicts are always there in any legal representation. Between lawyer and client, the lawyer is billing by the hour, has the conflict, they want to bill more hours, but they shouldn't, they know they shouldn't. They should bill the number of hours that will get the best result for the client, including taking into account the legal fees. So you have that conflict on the defense side when the lawyer bills by the hour. The contingent fee lawyer has a conflict, and that's what I pointed out in my 1998 article, litigating on a contingency, a monopoly of champions or a market for champerty. And the plaintiff's lawyer has, of course, a conflict. You might have a portfolio of lawsuits and it's time to pay all your associates, so, well, we better sell something from the portfolio. That means you settle. You settle cheap. Well, now, I hope most plaintiffs' lawyers wouldn't do business that way, right? That'd be unethical. You should make sure that you are advising the client based on the client's best interest, not the law firm's cash flow needs. Or on the other hand, the plaintiff's law firm with a diversified portfolio of cases might very well say, you know, this is the case in which we're going to teach those defendants a lesson. We're going to, oh yeah, let's get tough. And, you know, they go, they fight, but they're able to lose. They've got a diversified portfolio. So they go to the client and they say, let's fight. And then they lose. That client had only an investment at stake in one lawsuit. So there's a conflict. I mean, you got lots of conflicts with contingent fee lawyers, conflicts for corporate lawyers. Before Donald Trump came along, I made my career writing law review articles on and being an expert witness in cases on conflicts of interest for lawyers. And yet somehow now conflicts are a problem. No, they're always going to be a problem in the practice of law. But the answer is disclosure, full disclosure, informed consent from the client. And, you know, when you see a situation, you've got to look out after your client. It's not just disclosure, but that's very, very important. But, you know, if the litigation finance firm you have a relationship with is not giving the best deal, if there is an alternative that you know of, you need to explore it. So you need to zealously represent your client and disclose the conflicts. But we will never make conflicts go away from litigation finance or any other area of the practice of law, including the conflicts of interest of the Attorney General of the United States, who worked on the Russia investigation in the private sector. He worked on it. He communicated with the lawyers, the defense lawyers. He interviewed with Donald Trump to be his personal lawyer on the matter, and Donald Trump found a better position for him. Let's do an inside job. I mean, talk about conflicts. And of course, they're going to stick to the position the President of the United States should not be indicted while he's in office. Well, the only case law I've seen that comes close is Jones versus Clinton. Says the president can be sued civilly while he's in office. How many Republicans were pushing that big time 20 years ago, and now they're all like, well, sort of, maybe. So the hypocrisy. That's back when Ken Starr was hired a young lawyer in D.C. named Brett Kavanaugh to draft up some very, very explicit questions on what happened in the Oval Office between Monica and Bill. Then Brett Kavanaugh writes this law review article in Minnesota Law Review in 2009 talking about how the president should never be investigated. Well, that's an oversimplification, but that's 90% of the article right there, because it might interfere with the president's ability to carry out his duties in office. Law review article questioning United States versus Nixon, ordering the president to turn over the tapes. I think I can figure out why he got the nod for the court, but I don't want to insult a justice of the court. I don't make too many waves.
Eric Schuler. One of the other arguments, kind of going off of what Tony said earlier with the chamber is disclosure of the existence of litigation finance in cases. And one of the arguments that the chamber likes to say is, well, we need to know if that judge in the case has an investment in a publicly traded firm or a mutual fund or whatever it is, so they can, disqualify themselves or not disqualify themselves. How much of that should be disclosed? You're talking about disclosure to the plaintiffs and to the attorneys, but to the judge in the case, if there is litigation finance.
First of all, a judge should not be investigating a litigation finance, obviously. So if the judge is putting the judge's money in a private equity fund that does a piece of litigation finance, that should be prohibited by the judicial conduct rules. We should focus on what the judge does with his or her money. And a mutual fund, on the other hand, conflicts of interest from mutual funds are not passed through to the judge. In other words, if you have a mutual fund with 100 stocks in it, and one of them is General Motors, and it's a case against General Motors, you, the judge, are not disqualified from the case if it's really a diversified mutual fund that you have. I mean, judges have to put their money somewhere and not under the mattress. It should be in mutual funds. And I, again, emphasize how much I've tried to get federal judges to move their money to mutual funds and conflict-free investments away from individual stocks, where you can get into an awful lot of trouble. And yes, litigation finance could be another area you could get into trouble. But here, I don't understand why the parties should have to disclose the details of the financing to the judge, if the judge could simply invest in mutual funds or in companies that the judge knows are not involved in litigation finance. And that should be a breach of the conduct rules, no more than if we were to allow judges, if we were to allow law firms to raise capital from lawyers outside the firm, you can't have the judge have a piece of a law firm and has a case in front of him.
Ralph Sutton, Validity Finance. Professor Painter, you might know that in the UK, lawyers are now required to inform their clients about litigation finance options. And that's partly because they have adverse cost risk, and there's insurance for after the event types of risk. And so there, the professional responsibility gurus have decided that that's important for lawyers to do. Do you think we've reached the point here where the duty of competence now requires lawyers in the United States to inform their clients of litigation finance options?
I believe they should. Whether that would be held to be obligated under our rules, the way our rules are structured by court, I don't know. I think lawyers should. And this is the point I made in my article back in 1998 about the monopoly of champions, that the plaintiff's bar is the only place you can go for your financing, for your lawsuit. And what you're getting from the plaintiff's bar are three things, three products all rolled into one. One, the legal services. Second, a loan financing. You're not going to pay for the legal services now, but you're going to pay later when the case is decided in your favor. So you're getting legal services plus a loan financing. But it's not a debt obligation where there's recourse to the client. There's recourse only to the judgment or settlement amount. And so the third product you're buying is litigation insurance. And so you're getting all three, the legal services, the financing, plus the litigation insurance component from the plaintiff's bar. And under the traditional Champerty laws that were, I believe, a little stronger with the time I wrote that article, we still have this problem in quite a few jurisdictions. The plaintiff's bar is the only place you can go. Now we've loosened that up by loosening up the Champerty rules. But American individual plaintiffs don't understand that that is a place to go, that that's an alternative to simply buying all three products from the plaintiff's lawyer. You could buy the legal services from the plaintiff's lawyer and at least some of the litigation finance, the financing plus the insurance from an outside financier. And the lawyer should inform you of that. And the reason it worked out differently in the UK is the UK never liked contingent fees to begin with. So they were a lot stricter about contingent fees. So the question is, where would you go to fund the plaintiff's side of a lawsuit? And of course, the corporate interests in the City of London would like to say, nowhere, we don't like plaintiffs. But as they started to be concerned about justice and access to justice in the UK, they did not have the traditional American contingent fee. It was not as robust. There were many more restrictions on it. And so they started to look at litigation financing about the same time that they liberalized some rules on contingent fees. So there's a different history there. So I would tell you what the answer should be, but I would be going too far to say what the answer would be. Does the lawyer required under the ethics rules to communicate with the client about the availability of financing? I think the lawyer definitely should. And if the contingent fee comes in too high and the client wants to complain about it, saying, well, I wasn't told about litigation financing alternatives might be a good argument in defending that, the client's position.
Any other questions? We probably have time for one or two more questions.
Josh Meltzer, Woodsford Litigation Funding. This question is very general, but we can view it through the prism of litigation funding. What, in your opinion, can the industry do to get the truth, get the facts out there in an environment where the other side may be outcome-driven and, frankly, not persuaded by whatever facts we're able to assemble? And I think this is a phenomenon we're seeing in a lot of areas in our country, and I'm just wondering, what can the industry do to be more persuasive with respect to its interests?
This is a challenge, because what you're stepping into, what this industry is stepping into, is a decades-long battle between the plaintiff's bar on the one hand and the Chamber of Commerce on the other. And you're stepping into a situation where you are welcomed by some parts of the plaintiff's bar and not others. So there is a mixed reception over there on the plaintiff's bar side, and then the Chamber of Commerce is uniformly aligned against you. And this is, of course, a very political divide. And going back decades, we saw the Chamber of Commerce raising money to put conservative judges and justices on the state courts through elections. And of course, they are very active in reviewing federal appointees as well. But they'd actually raise money for state judicial elections. We recently had a big case settle in Illinois involving campaign contributions that were allegedly made by a large corporation to help elect the judge. So you got lots of money there on that side, and then lots of money coming from the plaintiff's lawyers on the other. It's, of course, very partisan. It's become a Republican versus Democrat thing. Outcome-driven, and whenever it's a Republican versus Democrat thing, of course, everybody's screaming fake news while pushing their own fake news out the door. So that's what you've stepped into. Personally, I think the best way to approach it is try to be nonpartisan. Don't get into other issues having to do with plaintiffs versus defendants, civil litigation reform, and all the rest of it. Let other people address tort reform. Obviously, if you're on the plaintiff's side, you're going to have a certain view on that. But I think the litigation financing industry it's not a good idea to get into the political morass where people tag you as on the blue team as opposed to the red team or whatever, when the vast majority of Americans, by the way, are on the purple team, or I'm sick and tired of it all team, and focus on the facts, good old-fashioned facts, not fake news. And that what this is about is equal access to justice for ordinary people against the big companies, yes. And they have access to all the financing out there, massive global capital markets. And this is just to give the little guy an equal shake. But while you go down that route with that rhetoric, you want to stop short of getting into a partisan spat. Because the partisan politics, it boomerangs on you. And then the next thing is someone from the other party gets in, they say, okay, we're going to try and shut down all the litigation finance or whatever. You do not need that. Or they stick the Attorney General investigations are now so politicized. And that's the last thing you want.
I could listen to you all day, but one other quick question if I could. What do you think is the most credible criticism of litigation funding from the other side? Like, which argument would you be most concerned about, or would you advise a group of funders to think the hardest about?
If I'm going to advocate for the Chamber of Commerce position, what I would push is, we got litigation financing. If we're going to go that way, we ought to go whole hog. Do it, that's fine. But English rule, you lose, you pay our fees too. As they would try to say, well, look, there are two different dynamics, the United States and Great Britain. But the old English rule is, you sue someone, you lose, you got to pay that bill from Sullivan to Cromwell or wherever, or Wachtell Lipton. Yep. That's the English rule. The Chamber of Commerce has been trying to get that for decades without success. But and the argument against the so-called English rule is individual plaintiffs can't bear that burden, and neither can their lawyers. Lawyers can barely fund what they've got going on. Once you got litigation finance, say, hey, all right, but you sue, you lose, because there's so many frivolous lawsuits out there. I mean, look at all those people suing Donald Trump. I mean, frivolous lawsuits. Yeah. Mm-hmm. Oh, well.
Is there a last question, quickly? All right, thank you so much, really appreciate it.
Thank you very much.